All right, we are live streaming now, and the courtroom clerk may open court.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Thank you. Will the clerk please call the case?
This is Supreme Court case number CVA 21-009 in the matter of the guardianship of Yuklon Moylan Ward. Appearing for the appellant cross appellee Richard E. Moylan is attorney Douglas B. Moylan. Appearing for the appellee cross appellant Lena Lealoha Moylan Alston is attorney Jacqueline T. Terlahi. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Moylan reserves 3 minutes.
Thank you, Madam Clerk. Good morning, counsels. At this time, Attorney Moylan, you are recognized.
Chief Justice, may it please the court. We have identified 2 issues on our appeal of the trial court's decision issued on June 15, 2021. However, this case is actually a remand order by the Supreme Court from its opinion 2018 Guam 8. The 2 issues that we are asking the court to review appears to have been a misapprehension between the former judge, Judge Michael Berdallo, and the newly assigned Judge Elise Iriarte, who was the trial court decider. On June 4th, the former judge had a hearing on our mandate arising from 2018 Guam 8. The court orally ordered certain parameters for the counsels to follow. Because we're dealing with a 12-year span of time in order to provide the invoices pursuant to what the judge ordered, we filed our brief on December 2, 2019. Judge Iriarte was assigned on September 22, 2020, essentially after the briefs have already been submitted by Richard Moylan, the interested person. The oral argument occurred on March 10, 2021, and her decision issued on June 15, 2021. We also requested reconsideration, seeing that the court appears to have thought that we submitted all the invoices over a 12-year period. As to the TCD and the House issue, which were 2 of the 5 that we identified, the court split it, saying that the rest of it must have been non-TCD or House-related issues. We attempted to
Mr.
show
Moylan,
the court.
One of the things that you pointed out was that you felt the judge believed that you submitted all the invoices and not just those that were for providing a substantial benefit to the wards. But didn't the judge in the decision and order in the motion for reconsideration make it clear that that not all the entries had been submitted, but only the entries that you believe had conferred a substantial benefit? So she was aware that the timesheets that you submitted weren't for all matters, including those for which there was no substantial benefit. I mean, I read that in her decision and order in the motion for reconsideration.
Justice, you are correct. However, excuse me, when you look at the actual invoices and how the judge is characterizing them, we pointed out that if you compare the Superior Court of Guam file documents with what we submitted, we did describe them. We did not include such as the accounting, the motion to remove the guardian. There were many different issues that were brought up. So we would respectfully disagree with that characterization as it appeared in the decision, because when you actually look at the invoices that were submitted, they actually are focusing, and this is again pursuant to what Judge Berdallo ordered. He specifically said,
I think when the way I read the judge's decision is she seemed that she was awarding for less than the 5 issues. She had made that decision. She was clearly agreed to, pursuant to our mandate, that the return of the TCDs and then the House. But she had made a decision to cut the entries where she thought that there was work that was being performed or submitted in the invoices that related to other than just the TCDs in the house, or it wasn't specified what work was done for one issue. So that when the entry covered work that was both recoverable and unrecoverable, it seemed that she made her decision to award fees for only those two categories. And so she cut the billing.
Your Honors, I would respectfully ask that if that was the case of how the trial court had handled it, that we be given the ability to have complied exactly with how this new judge had requested it. We believe that it was a unfairness to the interested person who had spent great efforts in order to attempt to recover the funds. And again, if the court was to look at the actual file, to get to that trial in order that TCD to be supported, other issues were coming in, such as, for example, I believe it was the 2007 October attempt to take the money out of the bank account and use it towards the business operations. That wasn't directly related to the TC, but it was related to maintaining it. If the court felt that—
Well, if I might just interject this time, at the time Judge Verdalio, the hearing that you referenced, issued his oral order and what he would like to see in terms of the invoice, he had asked that the invoices be separated. One clearly was relating to the 1.5 million that was awarded in reference to the property. He said that he would look at that, and then any other matters that you felt that resulted in a substantial benefit to the estate. And then pursuant to that order, you filed your invoices in a linear format,
Yes.
just restricted, as you said, to the categories that you contend resulted in a substantial benefit to the estate. So this is how you responded to Judge Verdalio and Judge Elise, Judge Uriarte, excuse me, having this record before her, and recognizing that it was your burden to separate the invoices as requested by Judge Verdalio. Having this record before her, made the decision, and she has the authority. She has the authority in awarding reasonable fees in reference to adjusting upward or downwards. And this is what she did based on the record that you had provided to her before she made her decision. Is how I'm understanding the record.
I would respectfully ask the Supreme Court to understand that as the courts are aware in your prior experiences, the trial practice of being able to understand exactly what the judge wanted, if he wanted a separate piece of paper for just those invoices for the TCDs, because of the 12-year period, it seemed to be efficient for this counsel, as the trial counsel on the matter, to have identified it linearly, but then put the specificity in the description. And I will defer, I did not fully understand, maybe if that's the way you interpret Judge Verdalio's verbal order, and I just leave it to that point that it just seems unfair that we not have been given an opportunity to fully ensure that at least the form didn't defeat the substance of what the Supreme Court afforded to Richard in this case. I believe it would be a fair representation to say that he was a good Samaritan in trying to recover things that he would have no ability to receive. And I believe the Supreme Court's opinion was that in that regard. And this was precedent setting for purposes of the Supreme Court of Guam and the rule that has now been established. Your Honors, I am just basically asking the court as former practitioners and as human beings, this was not an easy task, not only in the litigation efforts, and trial court Uriarte clearly recognized that the amount of litigation in this case was tremendous. The number of case files are tremendous. And to come 12 years later to be able to receive such a beneficial type of decision from the Supreme Court, to have Richard suffer, it just doesn't.
Judge Uriarte seemed to have taken that into account. I mean, this is an issue that Attorney Terlai, I'm sure, will be addressing, but Yeah, she also adjusted your fees. Your normal billable rate is $250 an hour. After some confusion, you clarified that you were requesting $300 an hour. And she recognized the complexity of the litigation and the various factors that justified an adjustment of the hourly rate upwards. And so I think Judge Uriarte, in determining what reasonable attorney's fees, um, what that amount is, took that into account. And so I'm not I'm trying to point out is that she tried to also be reasonable in awarding the fees based on the record that was before her.
That is correct. She was attempting to be reasonable. And I was seeking to see if the court would, given the 12 years and the complexities and the amount of time to even put together these invoices, would have allowed counsel to basically say that, I'm not sure what you're saying here. Can you please clarify it? And that's why I've asked this court, this panel, to allow the discretion of a practitioner, the benefit of the doubt. There was no written order, Your Honors, and I don't want to belabor the point with you, Your Honor. So,
yeah, and I only point out because you're appealing to equity in terms of fairness, and I'm sensitive to that. But we have, in my view, we have a record that is before us that has gone through a motion for reconsideration, and Judge Uriarte went back and listened to the tapes to make sure that she heard what Judge Verdaliu had issued, and it's an oral order, and so she went back and she reviewed that, and she had determined that it was clear, at least in her mind, as to what Judge Verdaliu had requested and what was asked of you, and in the motion for reconsideration. I guess you also had that opportunity if you had a second bite of the apple in reference to that motion for reconsideration. And so she properly weighed this in my mind in making her determination based on what Judge Verdaliu had issued.
Your Honor, I would ask the panel to, the fact that the invoice was slashed by 1/2, I think that says a lot, because it doesn't get into the merit of each one of those entries that were provided. We had provided essentially 46 pages of invoices, and even the judge required the spreadsheet and provided 26 pages of invoices. But instead of specifically saying that this one it included other issues and this one did not, it was just a wholesale slash of 50%, which again is the reason why we bring this. I would also ask on the issues, she only took 2 of the issues. And then she said, well, you didn't talk about the other issues, when in fact our reply that was filed on November 18, 2020, excerpt of record 98, specifically went over each one of the cases that opposing counsel was saying, hey, you're billing for this, you're not billing for that. And we specifically identified those cases and provided an explanation of why we felt it fell under the substantial benefit doctrine.
Well, so, I think where Judge Uriarte, if I understand her her order, may have disagreed, because Judge Verdaliu had stated that you would be allowed to provide arguments to justify how the estate had benefited from all the work you did in the other categories. Just providing a linear invoice in reference to references as to what you had billed, it's not the argument that substantiates how the estate benefit, at least I understand in the minds of Judge Uriarte, or at least from what's reflected. And so, you had contended that you didn't know that you had to, provide an analysis cite to authorities. But, that's what an argument means. When they say you can argue, you have to provide that explanation.
Your Honors, I thought that the Supreme Court had set the legal standard, and that was the substantial benefit. So most of it would have been fact-driven. and an analysis by the courts of the type of work that was presented. And in fact, in our opening brief submitted under the former judge, on page 20 of that brief, actually the excerpt of record 20, and then page 2 of the brief, we specifically identified the 5 categories of work that they were being submitted upon, which was complying with what Judge Bordallo had requested. And then in the invoicing, it specifically identifies house or TCD or corporate loan or liberty interest.
That's the disagreement. It's not what was done, it's how it benefited the estate. Although the substantial benefit doctrine was announced, we didn't provide any tests in reference to how that may have been determined, because it was, in our view, is very obvious that recovering the $1.5 million in the names of the wards under any test would substantially benefit the estate. But just what you did is, in the mind of Judge Uriarte, is not sufficient in terms of how it benefited the estate. And I think that may have been what she was looking for.
Yes, and that is clear, and I agree with you, Your Honors. And that's why I don't take this as she made an error. It's just that I was under a different impression with Judge Bordallo based upon an oral hearing that we had. And my notes and even the transcript appear to reflect the judge wasn't very clear on how he wanted the formatting, what type of legal argument he wanted. In the footnote of the Supreme Court, it specifically talks about what the court, what you just indicated, Chief Justice, on that issue. I agree. But at the same time, it wasn't clear, are we supposed to be arguing a whole new substantial basis test for liberty rights or for something like that? I wasn't able to fully comprehend possibly what Judge Bordallo had ordered, and a remand to clarify that with the court. And especially when you add on Justice or Judge, the trial court judge's interpretation of the former court decision, and it wasn't even written. She had to go to the oral audio record to take a look at it. There was no transcript. So, Your Honors, it just seems to be a unfairness to counsel given the situation, and I'm not attributing fault to anyone on this. Maybe it's my fault for not going back and asking for a written order, but that judge was no longer available. By the time
I think Judge Uriarte, in going back and in looking at what Judge Bordallo said when he indicated he would allow you to argue you were entitled to recover fees under the substantial benefit doctrine for those items beyond the TCD in the house. When he says argue, I mean, that seems to suggest a requirement that you support the basis with facts and legal argument, for example, on the civil liberties issue. But yes, I think we've already gone through that. I want to go back to looking at the standard of review because you argue for a de novo standard of review, and clearly in deciding whether or not the legal basis for an award of attorney's fees is a legal determination that would be reviewed de novo. But the trial court's award of the attorney's fees and her decision, don't we look at that for an abuse of discretion?
Yes, you do. I would agree that there's a different standard of review if we're solely talking about a attorney's fees review on whether you're entitled to it. However, because of the rule of mandate, compliance with the Supreme Court's decision is by de novo. Then you have the first trial court judge indicating, okay, this is how we're going to, it's really a formatting and an understanding on how the judge wanted these billings to be submitted. I can hear the court is concerned that it was linear. In the decision or the order of the judge, he didn't say in terms of don't make it linear. He wants one page on for this category, one page for that category. It could be done. And if you look at the, again, that excerpt of record 20, I provided the 5 categories, and then I provided the linear breakdown and identified those 5 categories within the description. I do agree that if for example, the 1/2, cutting it by 1/2, it doesn't seem that each invoice was looked at because each invoice, each work that was done was for a different issue. And we had a plethora of many different issues depending upon what the time billing was. So it didn't, the wholesale cutting of the invoices doesn't seem it seemed to have fallen within that abuse of discretion, a clear error, a misunderstanding, misapprehension.
Well, like for example, Judge Iriarty in the motion for reconsideration and the denial of that said she had painstakingly reviewed your submissions, and even though Judge Berdallo told you to segregate it, that you didn't adequately, in her mind, differentiate which work applied to which litigation effort. And she pointed out, like on category 3, work went towards different areas, not solely to the recovery of the TCD. And you know, she said that you had submitted time entries for all of the instances where you felt that there was substantial benefit without breaking it up, as Judge Berdallo seemed to instruct, that you had to break it up by specific matter, segregate the work for TCD, segregate the work for house return, segregate the loan, the protection of civil rights. And so she seemed to go through that. And in those situations where she was not able to determine based on those categories, that she made that decision, you know, and how would we say that she abused her discretion when she evaluated Judge Berdallo's order, evaluated what you submitted, and made the decision that she did?
In response, I just have to defer to the appellate court's review of the record. The judges make mistakes, counsels make mistakes. There's limitations in understanding. The excerpt of record, and I know that it's a part of the contention, I would respectfully submit that they were not mixed, and that a review of our breaking it apart in terms of the invoices, you know, the whole invoice itself by date, it shows that they were not being overlapping. I think there was a few, maybe 1 or 2 that may have mentioned the house and the TCD, and I would defer to that. But the court seemed, again, it wasn't, this invoice is overbilled, this is not. It was just, I'll just cut it by 50% after adding everything together. But I'll leave it to the Supreme Court to make its decision on that. Your Honors, my main contention is that, and I have provided a case authority within the opening brief, that in situations where there's been a misapprehension or a misunderstanding, it would be appropriate to remand, not to change the decision, but to require further clarification of allowing counsel to fix whatever deficiency may have been counsel's fault, may have been a fault lost in the translation between Judge Berdallo and Judge Iriarty. It just seems that the situation warrants that, whether it's de novo, whether it's just basically a remand order to make it clear, make the record clearer. That is where I am coming from, Your Honors. So,
Mr. Moylan, did Judge Iriarty reject as a basis substantial benefit the time spent on the loan recovery, because she said the estate didn't end up benefiting from that?
I believe she did, and again, we did provide the argument for that in our moving papers, and that is one of the issues on appeal. But I do recognize she did say the loan issue, so I'm not, and that was always difficult to begin with. But as the court is aware, we never brought that up. That was Judge Barrett Anderson originally, and we just defended it on the appeal. We never argued about the loan. That wasn't our basis for appeal. It was the majority siblings were appealing that decision from Judge Barrett Anderson.
But didn't you submit billings for that?
Yes, we did, because we were defending the trial court decision. That was Judge Barrett Anderson at the time. But we do recognize that was up for review on whether or not it satisfied the substantial benefit test. I recognize that. I believe that the Supreme Court had indicated in its opinion, and clearly, that when the ward receives an actual financial benefit, it's a stronger indicator of a substantial benefit. But in our briefing, and I included it as excerpt of record 98 through 103, we specifically provided facts and the authority provided by the Supreme Court. So that's where I would differ, especially with the decision when it makes comments. Well, you never argued it. we have it on our reply brief, and it specifically has topic headings with case numbers, both Superior Court and Supreme Court. And I specifically referenced the decision from the Supreme Court where it should be.
But if she
Understood.
decided that it wasn't a substantial benefit, didn't she decide that issue in removing those hours?
No, yes, she did. And that is not part of this argument. I'm saying that where the 50%, because she identified, and it was clearly identified in the billings, TCD or house return, those sorts of things. The corporate loans were separate. And that's why I have tried to make it easier to understand by putting in the excerpt of record. I know opposing counsel has an objection to that, but this is what she was doing. This is what I did. We don't seem to be inconsistent with it because we're not modifying the descriptions. The corporate loan were
So if we were to remand, it seems to me we shouldn't remand on that issue. It should only be the TCD and the house recovery.
Thank you, Your Honor. I would respectfully ask that given the arguments that were made, that the Supreme Court has that ability to just review it. It was appealed. She did clearly say no corporate loan. I knew, and even Justice Judge Berdallo understood, that was a precarious one because the estate never benefited from it. They never received a financial benefit from it. So I guess it's an evolution of what a substantial benefit is by the Supreme Court on whether or not non-financial benefits can occur, i.e. trying to defend the lower court decision. Judge Barrett Anderson said the estate is entitled to the corporate loan repayment. And then we had to take it on the appeal because we were the appellee on that issue. So I would leave it to the Supreme Court, but Your Honor, you are correct on how you characterize it. I would respectfully ask that because we've appealed that issue, that the court actually look at whether or not the corporate loans qualify under its substantial benefit test. And it was briefed to the lower court. Yes.
I believe your time is
Winding down.
Winding down.
Do you wish to reserve your remaining?
Yes, I
time?
will. I will. Thank you.
Thank you, Mr. Moylan. Attorney Terlahi, you may proceed.
Thank you, Your Honor. May it please the court. The trial court's award of a $300 enhanced hourly fee resulted in a punitive damages award to Richard. The substantial benefit doctrine was not intended to be utilized as a sword against elderly incompetent adults, and the record clearly rebutted a $300 reasonable hourly rate to $250. Conversely, the trial court correctly rejected Richard's request to shift $473,310 in attorney's fees to the wards because it was Richard who failed to identify, to detail, differentiate, to categorize his request for attorney's fees. All his efforts in the 9 appeals, the 6 petitions of guardianship, the 2 writs that were presented to the court, all his efforts did not substantially benefit the wards. And the trial court correctly declined to shift the full burden to the wards consistent with the substantial benefits doctrine and correctly apportion the number of hours based on the inadequate record provided.
Attorney,
Now,
at the March 10th hearing, didn't the judge unambiguously grant the request for 300 when she asked Richard what his billing rate would be, or Mr. Moylan?
That is correct, Your Honor, and that is the basis of the appeal by the limited guardian in this case, is that the court unequivocally found that there was a $300 reasonable fee. We objected and we opposed to that.
But you're not objecting on the grounds that the fee is reasonable. My understanding is that you're objecting on the ground that the submissions and the billings that were showing a $250 rate, right?
And that kind of would be correct, Your Honor. Our objection is the basis of the substantial benefits doctrine. The underpinnings of the substantial benefits doctrine required the trial court to undertake a review to determine, 1, what was reasonable, whether or not there could be a potential windfall, and whether or not there resulted in unjust enrichment to any party. Because the substantial benefits doctrine, as ordered by this court in Moylan 3, was to specifically avoid any windfall to either party, to avoid unjust enrichment to either party. So what happens when the trial court enhanced the fee to a $300 an hour, that results in a punitive award.
But is there, I mean, I did not see anything in the record where the actual amount that Richard was billed was part of the record, or his fee agreement. I mean, we have the invoices that show that the normal billing rate of $250 that you can ascertain based on the hours and the total time. But so although the record has invoices and statements about billable rate and what Doug Moylan's usual rate is, I don't see anything where the actual billed rate or a fee agreement with Richard is part of the record. And the judge went through when she asked Mr. Moylan, what amount are you requesting for this case? And he said $300, and the judge found that to be a reasonable hourly rate, noting the prevailing rate in the community and the complexity of the work that was done and the amount that was awarded to the guardian ad litem in the same amount.
Your Honor, I want to be clear that it is not our position that a 300 rate is not a reasonable fee as set by the community. Our appeal is based on the fact that the substantial benefits doctrine is an equitable remedy being granted to Richard in this case. We know that Richard has already been found by this court to be entitled to attorney's fees. However, a trial court is required to undertake not only a review of the invoices, but to ensure that there is no windfall. And in this case, when it is clear from the declaration submitted by counsel that he bills his clients $250 an hour, that gives the court sufficient evidence to find that by asking the court for an additional $50 an hour, that there is a tremendous risk that the party being punished in this case would be two elderly incompetent individuals. And that is the reason why it is the burden of the party to present to the court not only just an adequate record, but the court has to undertake some form of review.
But
in this case,
but the fact that Mr. Moylan submitted invoices that showed a hourly rate of $250, I think does not necessarily establish that that is the amount that Mr. Richard Moylan, agreed to pay.
and you're correct, Your Honor. I agree with that assessment by the court. However, it did give rise to a finding by the court that he normally has a bill of $250. That's also supported not only by just the invoice, Your Honor, but supported by the declaration of counsel sworn under penalty of perjury.
I understand that, but when it finally came down to the question being asked by the judge, and what is it that he would request or seek to get paid for this matter, I think he made it very clear at the March 10th hearing that it was going to be $300 an hour.
Yes, and Your Honor, this is the reason why we believe that it's an abuse of discretion under the circumstances of the finding of equitable remedies that the trial court must undertake, whether or not she is causing a windfall or unjust enrichment.
If I may just say that I see the analysis as a little different when you speak of unjust enrichment, equitable remedies. In my mind, what that triggers is that you're equating the granting of the attorney's fees as part of the damages that is to be awarded. And in that case, what is the fixed amount in reference to what was actually agreed to incur. In this case, what was awarded was a reasonable attorney's fees. And the trial court chose to adopt the Lodestar method in determining what was reasonable attorney's fees to award in this case. And then you are very well acquainted that the components of that is the hourly rate and the amount of hours billed. And so in reference to the hourly rate, she had evidence that the amount that Mr. Moylan was billing was $250 an hour. And that can be gleaned, as just Doris points out, from the invoices. But she sought clarification in determining what is reasonable attorney's fees as to what is it that Mr. Moylan was requesting, regardless of what he billed. And he said, I'm requesting 300 because that's a reasonable hourly rate for the complexity of the cases and all the various factors that had been stated in reference to what was considered in determining whether or not that's a reasonable amount. And Judge Iriarty provided the basis when she provided the litany of why she felt that $300 was a reasonable hourly rate in applying the lodestar method, and that's what and she decided. Now it's for us to review whether or not that's a reasonable decision on her part, and so you're arguing, in my mind, as to whether or not the fees that were submitted were constituted actual damages, and this is the amount that he is limited to. And I just see it a little differently in reference to the award of attorney's fees in this particular case.
Thank you, Your Honor. I appreciate that the justices have this view, because I don't disagree that $300 is a reasonable rate. But what is before this court is the issue of whether or not, in an equitable remedy situation where the court has granted a fee shifting analysis to give attorneys fees under the principles of unjust enrichment and windfall principles, whether or not the trial court, when determining reasonableness, whether that trial court had the obligation to undertake more than just simply, is $300 an acceptable or reasonable fee in the case. Our position simply is that when you have a fee shifting analysis under the substantial benefits doctrine, that there needs to be an additional step. The additional step is whether or not it creates a windfall. Now, all the court has to do in this kind of concept is to take a look at the numbers.
Why would it create a windfall if a reasonable rate to charge would be $300 and he agreed to with his client for a $300 rate?
If he agreed, but he doesn't put that in a declaration that his client agreed to $300. For all I know, his client agreed pro bono. And if his client agreed that this was a pro bono situation, we are now, if we give Richard back all of the $300 for the 1,577.7 hours of legal services, assuming that there was a pro bono agreement in place, we have now granted a $473,000 bounty on the heads of two incompetent individuals. And that's the very reason why it is our position that in the situation of this equitable remedy on a fee shifting analysis, there has to be a component of windfall and unjust enrichment.
Ms. Chilati, I'm surprised you would characterize it as a punishment to the two elderly people, because didn't they get $1.5 million back plus their residence?
Your Honor, I'm sorry.
How is this punishment? The people that lost $1.5 million deposit and their home got them back. So how can you say it's punishing them to require them to pay a reasonable fee for the work that was done to benefit them?
Your Honor, as I said, the position is simply that a requirement of a component of a review on unjust enrichment and windfall under these particular types of circumstances should be conducted by a trial court. We're talking about two elderly, incompetent individuals. In this particular case, this court and the underlying trial court found that there was no ill will or deceit in the transfer of that TCD or in this house situation. So there was no bad faith involved. And yes, the wards did receive the benefit of holding an account of 1.5 million, but it is factually incorrect in this particular proceeding to say that the wards received the benefit of the use of those funds, because those funds were consistently restricted by the trial court. So in this case, because you have the public policy of protecting the Manumku, of avoiding elderly abuse, of preventing any continued abuse against elderlies, then what we need to look at is whether or not by shifting a fee, whether or not we as a system are causing an additional abuse on the elderly by compelling them to pay an amount that would be in addition to what the party who sought the benefit for them is acquiring. So for example, as I said, if we look at the numbers that are presented in this case, with the invoices that are presented in this case, the total amount billed at $300 an hour would have been $473,000 in legal fees, of which we all know, and the record clearly reflects, that there was not a full benefit to the wards of all of the issues. And this is why it's important that we take a look at how the trial court handled the review of the billings, and why the trial court was, in a sense, critical of what was submitted. Because
the trial court in its actions took that into account. It held Mr. Moylan responsible for properly segregating the invoices in its mind, because he felt to do that. She cut the fees, and she felt that cutting it in half was a reasonable amount after considering the record and the obligation of Mr. Moylan in reference to if he feels that he was justified for a certain number of hours for the work that was performed that benefited the state, that should have been delineated in the way that Judge Berdaliu had ordered, and since that was not done, the wards benefited because she cut it in half, and so there was that consideration.
Your Honor, and that is also why, in terms of this particular appeal, the limited guardian has asked the court to uphold the finding of the hours of the trial court's analysis. We felt was correct, right? That she went through the billings. She went through each of the categories. She looked at category 1 for the TCD, category 2 for the house, category 3 for the share loans. And she made that assessment on whether or not the substantial benefits doctrine was justified in terms of the preparation and the opportunity that all parties had to present their case to the court. So I know and I understand that the argument we are advancing on the reasonable fee, the wealth of the case law says a reasonable fee is reasonable, especially a reasonable amount in the community. We recognize that. But what we are asking from this court is in the circumstance of elderly abuse, elderly claims of abuse, that there be a more definitive standard on how the trial court should determine whether or not that elderly couple or one individual elderly person should bear the burden of the benefit of litigation. And in this case, simply because they were rich people does not mean that we should shift that full burden. In fact, this court said that it's a shifting of burden, it's an apportionment. And that's the reason why we say when you look at apportionment, you look at the justification and the policy against unjust enrichment and windfall, there has to be an additional assessment. For all I know, if this court remanded it to the trial court and said, well, you didn't do this, you didn't assess it for windfall and unjust enrichment, the end result may be the same. But at the very minimum, what we would have on WOM is now we would have a definitive standard for the trial courts, that the trial courts must undertake at least a bare minimum review of whether or not it causes a windfall. And in the end, the consequence is a punishment to people for being incompetent. That's what we are advocating here, Your Honors. We're not advocating that someone don't get
give some credit to the trial court that in reference to its consideration of Mr. Moylan's request, the court took the position that in reference to the shareholders loan, to the alleged civil rights violation, and in terms of the hours claim for computing the fees, arguing the entitlement of fees and costs, that was not granted, and that because the court felt that there was not a benefit to the wards, and only awarded fees in reference to the $1.5 million recovered, and the property restored, the house restored back to the ward's names, and it was only for those entitlements that the court awarded fees. And so there was a proper balancing, it appears, that the trial court took in deciding what benefit the estate, and so I just wish to point that out also.
Yes. And Your Honor, and that's the very reason, as I said, the limited guardian's position with respect to the court's review of the information before it, we take no dispute with. We believe that the trial court did in fact spend a substantial amount of time reviewing the record before her. Not only did she undertake to review each of the categories, there was a separate order requesting that the digital documentation for the support of those requests were submitted. The court had an oral argument on this issue. The court heard the motion for reconsideration. She addressed each of those motions in a timely manner. So from our perspective, we believe that the court did undertake a review. We are simply asking this court that the trial court's finding that the substantial benefits doctrine warrants the shift of only the 1,557.7 hours, that finding of the trial court should not be disturbed, and that there should be no remand. In this particular instance, we believe that there was no abuse of discretion by the trial court, and the record does not support a finding that the trial court's finding of fact was against any logic and effect of the facts before it. Your Honor, with respect to going back to the enhanced fee issue, I understand the position of the court. We simply are urging the court to adopt a standard of proof on the attorney's fees issue. Should this type of issue be presented to the trial court again, the trial courts would have a definitive standard setting forth how to review the issues. Your Honor, with that said, unless the court has any further questions, I believe I've addressed all the pertinent issues before the court. Obviously, we've also asked the court with respect to any documentation that has been doctored by Richard that was not presented to the trial court, that the court strike those particular documents in terms of this appeal in violation of the rules.
All right. Any further questions for attorney?
Let me just ask a question about the transcripts, because there was a request for the payment of transcripts by Mr. Moylan. And although your opening brief doesn't reference the March 10th hearing, I mean, one of the issues you argue is the 250 versus the request for $300, and you say that no transcripts were necessary to this appeal, but isn't that an important component of the court's ruling? I mean, that whole dialogue, and shouldn't the transcript have been requested for that issue?
Well, Your Honor, from our perspective, there was no issue in dispute. Mr. Moylan, Richard had already submitted to the court not only a declaration, but there was no dispute or before the court that the amount that he normally claimed was $250. Mr. Moylan, Richard, was the one who raised the issue before the Supreme Court on this particular appeal that he did not have any evidence of his billing of $250. But I would note for the court that the reason we have objected to any recovery of costs for those transcripts in these proceedings is because if the court reviews the filings in this case, he doesn't even use the transcripts in support of his argument. And so if he didn't use the transcripts in support of his argument, it is very clear that they were not necessary to the appeal. And the thing is, we are both cross appellants in this particular case. It is the burden of both parties to provide to the court the record as is necessary to the issues raised on appeal. And because we did not believe that there was a dispute because of the facts that were already on the record, we did not believe that the transcripts were necessary to these proceedings.
Thank you, Attorney July. Justice Torres, does that satisfy you?
I have no further question.
All right, thank you. And Justice
Thank
Mayer.
you.
All right, thank you, Attorney July. If you have nothing else, we will recognize Mr. Moylan to complete his arguments. And if I recall, you have a little over 4 minutes remaining, Attorney Moylan.
Your Honors, the invoices that we submitted on December 2, 2019 were not esoteric invoices. They included the declaration that was the cover sheet for those invoices. Counsel has misrepresented the record. Paragraphs 4 and 5 specifically identified the normal billing rate of $250, and in paragraph 6 specifically requests that we believe that the reasonable rate for this case, given the complexity, should be $300. So that was already signaled to the Judge Bordallo at the time that we believe that the reasonable rate was $300. Counsel is bringing in information that is not part of the record below. At no point, as Justice Torres pointed out, were we ever requested to produce the actual retainer agreement between myself and my client. Counsel should not be allowed to try to argue a case that has not been properly preserved down below or the record prepared. She could have done it, she did not. And that leads up to that question about the transcript. It was her argument that was being proffered to the Supreme Court. The March 10 hearing was the only hearing that was conducted by the trial court regarding the briefs, other than Judge Bordallo setting the order. The transcript was necessary to support her argument. It was not our argument. But even past that, the record is not ripe for judicial review. She has mischaracterized that we said that the actual rate for the client was $250. The Judge Uriarte made it very clear that she was looking at the standard that the Supreme Court set in paragraph 31 of its opinion that is up on the mandate, specifically says reasonable attorney's fees. It has no comments about what an actual fee might be, whether it was pro bono. So the argument that she's attempting to elicit from the Supreme Court is not developed. Your Honors, I would also ask respectfully, again, excerpt of record 20, it specifically identified the 5 categories. I recognize the corporate loans was one of them, but the 2 other ones were the protection of the liberty right for the awards and due notice, proper notice. That arose from the Supreme Court's, the litigation required by the Supreme Court in coming to its decision that was successful. That is the liberty right that we've requested, and it was briefed. And it is briefed on page 103 of the excerpts of record, which was presented before the court made its decision, Supreme Court CVA21-009. It talked about the liberty right that was conferred by the notice requirement that the Supreme Court created, plus it referenced paragraph 31 of the 2018 Guam 8 decision that was on the remand. I would respectfully ask that that case either be allowed to be remanded for the judge to allow further briefing on it, or consider that we did brief it. It is in there in the record, and that we should have a judicial review of it. Also, the substantial benefit doctrine, legal work that was invested into trying to get to this point where we're at now, we've requested it. That was under, again, excerpt of record 20. It was the last item of the 5, legal work related to recover compensable fees and costs. In our reply memorandum, we specifically provided on excerpt of record 102, Supreme Court CVA 16-016, substantial benefit doctrine, and went forward with providing numerous case authorities that would support the court awarding fees in that respect. We recognize 5 requests were made. The lower court, trial court found that the TCDs in the House, there was merit in that. The loans, the court disagreed with, which we are respectfully presenting on this appeal. And then the last 2, the court seemed to say, well, you didn't argue it, so I'm not going to decide it. But in fact, the documents show we did argue it, and it is in the record. At that, Your Honors, I'll submit. Thank you.
Thank you, Attorney Moylan, and thank you, Attorney Jackie Terlahi. Thank you, counsels, for your arguments this morning. The court will take the matter under advisement, and this time we will stand